I've listened carefully to the testimony, and the court's position is not much fun, frankly. The 3.131B says I need to consider the following factors: the nature and the circumstances of the offense charged, and the penalty. And as we've stated, there's a neglect of a child, a felony, false official statements, and basically obstructing an investigation, which is a misdemeanor. And I would call the nature and the circumstances of the offense absolutely bizarre. And there was nothing I heard today that changed my thinking on that. The other thing the court is supposed to consider under 3.131B is the weight of the evidence against the defendant. As to these charges, I would say it is substantial. In fact, it basically includes a confession from her that she's lying about the investigation. So as to these charges and no other, again, the weight is substantial, and I give it great weight. The defendant's family ties, that's something else I should consider, and I'm duty-bound to consider. She has a family here that loves her and that's been doing their level best. For them, I feel very badly. I also am to consider the length of residence in this community, her employment history, which is beyond spotty. I'm not sure she's worked as an adult. Her financial resources, which are nil. Her family supplies her with money. Her mental condition, which I can't begin to describe, and I'm going to order a psychological evaluation. Of course, charges haven't been filed. I think I can still order a psych eval. Does anybody want to be heard on that?
Not at this time,
Ordering a
Judge.
psychological evaluation by Dr. Jeffrey Danziger and Dr. Alan Burns to determine competence and whether or not they can shed any light on her thoughts. I need to consider the defendant's past and present conduct, including prior convictions and previous flight to avoid prosecution. She's not been charged before. There is no previous flight. The past and present conduct has more to do than with simply priors, and her past conduct here regarding her daughter is strange, and her treatment, actually I don't know much about the treatment of her daughter, but her past conduct is difficult to describe, and I guess my problem is the conduct is continuing up to and including this trial. She hasn't spoken, which is her absolute right, and again, I have a problem with her continuing conduct and aid in helping this investigation. I'm also supposed to consider the nature and probability of danger that the defendant's release poses to the community. I don't think she poses a release to anybody. The possibility of the relevant facts that are real troubling are the deputy's testimony about the canine cadaver dog that alerted on the car and then again in the backyard. That will keep me up tonight. I have a real problem with that. Counsel, you're correct. That's not proof positive, and you'll have a chance to challenge that later on, and we don't know what the number of false positives that a dog gives are. Once again, the charges are a felony of the third degree, 2 misdemeanors, and normally she'd be entitled to a reasonable bond, which would be according to the bond schedule. But again, I have some problems with the fact that her conduct just hasn't changed per se, and she hasn't been any help in this investigation. Not a bit of useful information has been provided by Ms. Anthony as to the whereabouts of her daughter, and I would point out that the Truth and Ms. Anthony are strangers. As to her ability to aid in the search, which seems to be the reason for getting out, her actions between June 9th and the date she was arrested indicate to the court that she has no real interest in searching. Again, her past and present conduct don't engender much confidence in the court regarding her ability to help find her daughter. And again, I don't really see much of a willingness to help the investigation. If past and present conduct is any indication, there appears to be a willingness to hinder the investigation. Having said that, I don't know that I can please anybody in my bond ruling here, but I'm going to go ahead and issue a bond. I have to set a bond. The law requires it. The court is setting the bond at $500,000 plus GPS, plus I don't know if she has. I guess the testimony was she does not have a passport, but she is to forfeit it if she does have it. The court's cognizant of the fact that that bond is way high, and the court can always reconsider the bond as well as the conditions of bond at a later date, and I will if the situation arises. We're done. Before you go, I forgot there's 3 counts. That's on count 1. This is 2 misdemeanors, $100 on each count. Thank you.
$100. $200. $500 and $200. $500.